Hi, my name is Nick Ballou, and I'm a patent attorney. This video is about my top 5 tips for patenting business methods. The issue with business methods is that the USPTO commonly rejects them under 35 USC as not being patentable subject matter. And the reason for that is there's case law that says that some business method patents are patentable and some are not patentable. And the distinction between the two can be a little blurry and is not very well defined. And then if you add on top of that, that there's 8,000 examiners at the patent office, they kind of view the law a little differently, can interpret the law differently. So there's a little bit of inconsistency about what business method patents are allowable and what business method patents are not allowable. So these are my 5 tips for successfully obtaining a business method patent. Tip 1 is don't say you are patenting a business method. Tip 2, avoid certain words, terms that make them think you're patenting a business method. 3, think of practical ways to implement the business method. 4, try using software to implement the business method. And 5, try using an apparatus or machine to implement the business method. So now I'm going to be going over each of these tips in detail. So tip 1, don't say you're patenting a business method. So this is going back to the main issue of this. So from MPEP 2106.04a, they're quoting the Bilski case. It says, the Supreme Court concluded that business methods are not categorically outside of 35 U.S.C. 101 scope, stating that a business method is simply one kind of method that is, at least in some circumstances, eligible for patenting under USC section 101. So that is clearly saying that business methods are patentable. You can patent some business methods. And then the difficulty gets in that they kind of carve out some business methods that are not patentable. So again, from the same section of the MPEP, we have some categories of abstract ideas. So we have mathematical concepts. We have certain that I've highlighted here, certain methods of organizing human activity, fundamental economic principles of practice, including hedging, insurance, mitigating risk, commercial or legal interactions, including agreements in the form of contracts, legal obligations, advertising, marketing, or sales activities or behaviors, business relations, managing personal behavior, relationships, or interactions between people, including social activities, teaching, and following rules or instructions. And then 3, we have mental processes, concepts performed in the human mind, including observation, evaluation, judgment, and opinion. So again, the Supreme Court has said that some business methods are not patentable, but they also have said that some are patentable. So it can be a little difficult. So this is a famous case example on the side. It's a Bilski versus Kapos, and the claim 1 from that case says, initiating a series of transactions between said commodity provider and consumers of said commodity, wherein said consumers purchase said commodity at a fixed rate based upon historical average, said fixed rate corresponding to a risk position of said consumers, identifying market participants for said commodity having a counter risk position to said consumers, and initiating a series of transactions between said commodity provider and said market participants at a second fixed rate, such that said series of market participant transactions balances the risk position of said series of consumer transactions. So that's some pretty technical legal jargon there. But you can see from there that that's not really directed towards technology. That's it's definitely a business method. And kind of the foreshadow of some of what I'm going to be talking in the next slides is that you can kind of see that, I think from a practical perspective, to implement that business method, you probably need some computers or some technology or something else that would be patent eligible and not have this issue. So in this Bilski versus Kapos, they tried going straight for a business method, and it went up to Supreme Court, and they said that that was not patentable. So tip 2 I have is avoid certain words or terms that the USPTO may think that you're trying to patent a business method. And I would say that you could use these in the description of your patent application. You could say that you're doing this for banking or mitigating risk, or it could be used in insurance or sales. but I would kind of describe the invention, just in general terms without saying that it needs to be, for these sales activities or cost price or insurance. So some of the words that have been identified as kind of triggering business method treatment is hedging, insurance, mitigating risk, legal matters, contracts, settlement of obligation debt, advertising, marketing, sales activities, coupons, cost price, credit card, credit debit. So when you're writing your claims and saying what your invention is, I would try to avoid terms relating to that. And an example I have here is a patent I found for Visa, which is obviously a credit card company. And so they have a lot of patents focusing on transactions. And I'm not going to go through this whole claim from this patent, but if you look at it, so it says a method of processing a remote transaction initiated by a mobile device, the method comprising receiving by a server computer a transaction processor in the form of a merchant application. Next step is decrypting the encrypted payment information, determining a transaction processor, re-encrypting. Then the next step is receiving. Then we have validating, verifying, extracting. So if you look at this example claim I have here, this is aimed towards, a credit card transaction, which may be something that would be rejected for being a business method, but they focus on the technology here. So they do have some kind of words that, they have like merchant and payment and, some words that, I would try to avoid, probably in the independent claims. But if you look at the steps are receiving, decrypting, determining, re-encrypting, receiving, validating, verifying, extracting. So these are all very technical terms. So unlike that Bilski-Kapos case, where they didn't have any technology in the claims, this is clearly, focusing on the technology to implement this. So tip 3, think of practical ways to implement the business method. And so I have a few examples I'd like to talk about here. So if you look at Tony Robbins, you can go to his website that I have listed there, and these are the products that he's selling. So he's selling Money Masters app, Ultimate Relationship app, personal coaching app. He's health supplements, calendars, planners, and a bunch of other stuff. So, and if you look at Stephen Covey's website, you'll see planners, binders, covers, planning accessories, bags, and inspirational items. And my point here is that these are kind of business leader guys. Tony Robbins and Stephen Covey, they're not the calendar experts. They're not the supplement experts. They're not the app experts. What they do is they have these ideas about how you can manage your business, how you can manage your life and be successful. But those big ideas like that are not really patentable and they're hard to protect. So what do? They think of practical ways that you could implement these ideas as these apps, these calendars, these little devices, and then so that's how they implement their business method, and that's how they can protect it. And a couple other examples I have here are Airbnb. So the main idea for Airbnb is obviously you have some private individuals, they want to rent out property, and then they're trying to connect those people with, customers that would want to rent out those properties. So that's a business idea, and that may not be patentable, just renting out properties to people. But what they do is they have a lot of patents, and they have these apps and websites and different technology that enable that business idea. So that's how they're able to protect their business idea. Similarly, Uber is ride sharing. So we have some people that want to offer people rides in their cars, and that's probably a not protectable business method on itself. But again, they have a lot of patents. They have the app that shows you where the car is, how much the prices are. They have surge pricing. They have a lot of different features that are technical that are used to implement their business method. And then that's how they protect their idea. So I have an example here on the right. That's an Uber patent, and it's autonomous vehicle routing using annotated maps. So again, that's kind of their map user interface. That is patentable, and that's a practical way that they can implement their business method. So tip 4, try using software to implement the business method. So, and I have another YouTube video about top 4 strategies for patenting software. So a lot of times these business methods, you could implement them using software. So I had 4 good tips strategies for patenting software. And I think a lot of times that those could be used to protect your business method. One is user interface claims, 2 input-output claims, 3 whole device claims, 4 improvements of performance of a device. And on the right here, I have an example patent from the core wireless case, which is a famous case that I like a lot. And I like that case because it says that user interfaces are patentable. And these are the examples of the interfaces from that patent. It's basically an application launcher where you can go into messages, you see your new messages, and then you can create a message or enter a chat room from there. And then the court said that that is patentable. So you can see that these are fairly, normal kind of user interfaces, and that this is patentable. And then so my other YouTube video, it kind of goes into different ways that you can patent software. So I think, patenting your business method using software is a good way to do that. And then tip 5 is try and use an apparatus or machine to implement the business method. So I have some examples here. So I have automated teller machine, vending robots, RFID technology, robots automating a task, electronic gambling machine, smart lockers, self-checkout kiosk, medicine organizer. So these are all kind of, just different business ideas. You could, a vending machine, I've seen, just different companies. I've seen some like Best Buy or CVS vending machines, and that's kind of a business idea. Is like we can have vending machines out of the airports instead of having a little store, and this will be cost saving and increase profit. So that's kind of a business ideas, but then you can develop the actual machine, and that's how you can practically implement your business method. And then here on the right, I have just an example of an apparatus for implementing a business method. I say self-checkout, scan portal, and pay station environment. So this is maybe for a grocery store, any kind of store where someone's just checking out. So I think the business method there is, you don't need to have cashiers checking everyone out. A person can just, scan their items, pay, and then go. So my summary of recommendations for patenting business methods. So the practical tips are, think of practical ways to implement the business methods, software, machine, apparatus, objects, a lot. So you can have this business idea like Airbnb, Uber, like any of these kind of ideas, but you have to think of how you can practically implement it. And then, try to protect those practical implementations and not just the general business idea that may not be patentable. And then I say describe method while avoiding certain terms, words. I think you can, you could have a very patentable idea. You could have like Bluetooth or Wi-Fi, 5G, phone communications. But if you start saying that's for credit card processing, debit, for buying insurance, that'll trigger some patent examiners to say, no, this is just a business method, so this isn't patentable. So we kind of scrub the claims and the main descriptions of the main embodiments, and remove that, and just kind of have it more viewed as just directed towards the technology. So my contact information here is on the right. Here's my LinkedIn. If anyone's watching this, want to connect on LinkedIn, feel free to connect with me on LinkedIn. Here's my YouTube channel where I have other tips for other areas of patent law. And then here's the Gmail account where you can feel free to reach me. So thank you very much for watching this video.